Welcome to the Watch Project Show, brought to you by the Watch Project Media Group. If you have ever dealt with the wild world of homeowner associations or condominium boards, you know it can get a little crazy. Each show, we're diving deep into the politics, the news, and the unbelievable stories that come out of association living. Whether you're a board member, a homeowner, or just want to learn more, we've got something for you. So, let's get into it. Now, presenting your co-hosts, Dr. Deetra Poindexter, an executive director and the founder of the Watch Project, Michael Shepard.
All right, I'm your host, Michael Shepard, and I'm here with Dr. Deetra Poindexter, and you are now tuning into another episode of the Watch Project Show, where we go over association issues in the state of Georgia. If you're not from Georgia and tuning in, welcome. We'll eventually get to your state when we're done here at home. But we're going to be covering HOAs, POAs, that's a property owners association, which is a version of an HOA, condos, and now co-ops, which we have been instrumental in making sure that those individuals are now included because they were previously left out. We're going to be talking today about SB406. You already know that this passed unanimously in the Georgia State Senate, including the Watch Project Amendment, where we were advocating that if you create an oversight commission, that there is no HOA law firms or property management firms, not because we hate or despise those entities, but the vast majority of the complaints that we saw at the Capitol, that we saw being advertised in the news, came and was enabled by many people in these groups. Yes, we know there are many great property management firms, there are great individual HOA attorneys, but too many of the issues have been coming from this group to the point that we felt the need to be a proponent of that Watch Project Amendment, which passed unanimously. And now we're going to be talking today with my co-host, Dr. Dreacher, about SB406 and the House version. What are your initial thoughts about, what do we see with SB406 in the House before we jump into it?
Yeah, so what I'm saying is some positive movements,
Mhm.
and that's what we want to see. And we want to see where it works on both sides.
Yeah.
Don't take it as the Watch Project is attacking one side. We're not doing that. The point is we're trying to make the playing field even and understand what is the mission and the purpose of why we have these association. And at some point in time, we kind of like diverge away from the main issue
Mhm.
where now we have to call on the lawmakers now to kind of like step in and help and bring peace among the citizens that stand in these communities.
Agreed.
Okay.
Right before I pull this up, I feel compelled to state that there's a lot of conversation from what I would call the opposition, who do not want to see oversight, who do not want to see any change, saying that, how dare the state of Georgia get involved in private contracts? And we need to remind those individuals, and keep in mind, they know this, and it's a game to them. But the state of Georgia is not stepping in to interfere and dictate, the contents of a private contract per se. What they're doing is acknowledging the issue that entities are getting into a private contract, and you have one side or another, whether it be the homeowner or the association and their outfits through the HOA law firms or the property management firms, violating that. The issue is if a property owner violates that private contract, the association has a number of tools. They have an arsenal. Like, they are a superpower compared to an individual homeowner.
And then I look at it too, based off what you're saying here, is that they have all the knowledge. And when only one source of people have all the knowledge, and then you bring it down to volunteers, they're kind of like at your aid of the ones that develop all of this to guide you and direct you. And when they do so, you have no way of that knowledge to counteract with them. It's like their word, their written statements is what it's supposed to be. But what we're trying to do is educate both those homeowners that goes into those communities that have that type of covenant and bylaws that understand, hey, we might be volunteers, but we're also going to take the extra step to go to training or did more into work so that we can be completely understand so that we won't be undermined.
Yeah, and here's the other thing too. As a homeowner, if you're one of the few that may actually know your bylaws in and out, even when you do have that knowledge, if you're going up against a board, HOA law firms, property
Yes,
management firms, that they may or may not know the bylaw or even Georgia state law or even federal law. The issue though is you have very limited resources and limited avenues of resolve outside of the court system. And that's what when the association breaks their part of
right.
the agreement. Because rest assured, if you break your side of the agreement, you'll be getting fines. You'll be getting what all these fees.
Yes,
You'll have the law
yes,
firms on top of you, the property management on top of you. You'll be facing liens,
and
foreclosures,
foreclosures.
all of that.
Yes,
You're talking about losing your home, but what happens when it's the opposite? When you're in the right as the homeowner, but the association and their outfits are wrong. That's what the state of Georgia is addressing when the association is wrong and they're breaking their contract. So don't let the opposition tell you, oh, they're meddling in private contracts. I don't care what private contract you have. If one side breaks it, you have the authority and the right to seek reprieve through the government. So I don't even
right.
know what they're talking
And
about.
that's the whole point of why people love living in the United States, because we have a freedom of voice. You have that right to voice up what it is your concern, what is going on, explain and talk to me. We're not in
Mhm.
what is the word? Dictation. We're
Yeah.
not in some of the other countries, they want to be a dictator. That's
Yeah,
what
yeah, yeah, yeah.
dictator. Thank you, y'all. So, but that's what I'm saying. So we have the right to stand up and voice something. If something is
Mhm.
wrong, we should say something and don't get mad because we're saying something. We supposed to all work together and live in a country
Yeah.
where we can have peace among each other. So that's the reason why we have governing documents.
Mhm.
So to make sure that we just do just that,
Yeah.
live among each other in peace and harmony.
Well, hopefully, as Senator Matt Brass said, hopefully this legislation allows us to be going back to being neighbors. To paraphrase what he stated, and without further ado, I'm going to go ahead and pull up the House version of
Yes.
SB406. So right now, it actually made it through the House Judiciary Committee, and now what we're looking at is resting with the House Rules Committee. They may or may not make some amendments. I believe that they are before it goes to the full House floor for a vote. So I'm going to go ahead and pull up what we're talking about today. And this is like 16, 17 pages. So I'm actually going to go ahead and focus on just the highlighted passages that we talked about, because those are some important things that I think the majority of people are going to want to know.
Yes,
So
most
we're going to go
definitely.
in order, not of importance, but in order of how they have it written on this bill. So the first thing that we have highlighted is assessments. Why is this definition important? Assessment dues, they're used interchangeably, but with the Senate passed version, with the House version, what you're looking at is the association is no longer going to have the ability to foreclose on you for unpaid fines and fees. And so the definition of assessment is really important. And in the House version, what they did was go a step further than the Senate version of the bill. And they wrote assessment means and includes regular assessments, special assessments, and specific assessments. If you
And
live in an association, you know what an assessment is. You
mhm.
probably know what a special assessment is, but you may not be familiar with the specific assessment. And there's a lot of concern with this because if the association has the ability to foreclose on a specific assessment could be an assessment just sent to one person, and that could be, you know, potentially used as a fine and a
Right.
workaround.
Yes, yes.
So there's a lot of people who me and Dietrich work with that they don't like that. I have concern about that too. I personally don't think a specific assessment should be included in that foreclosure amount, because once again, this is something that can be abused, and this is something that that we both know are facing right now, where they're the ones hit with specific assessments, and in many of those cases, they are not shouldn't be responsible for what they're being accused of, and this could be a way to go after people and foreclose on them
Yeah,
too.
yeah, and that's
Yeah.
the truth. So we know plenty of people that has approached us and lawmakers at the Capitol
Mhm.
expressing this. So this is the reason why it is included in that, because it goes back to again, everybody want the American dream. They don't want their home to be taken away
Yeah,
from them over assessment or to find that, it's something that we could have just easily tried to work it out. And that's what good neighbors are about.
exactly. The next piece that we have highlighted, and I'll just read it. No person
Mhm.
shall operate a property owners association in the state pursuant to Article 6 of Chapter 3 of Title 44, Georgia Property Owners Association Act, unless such person is registered under this chapter as an owners association. The issue with this is that it's specifically referring to a POA right here, when it seems that the intent of the legislators, that they all agree that this bill will cover every single common interest community type, or in this thing they called it a owners association. So that should include your HOA, homeowners association, your POA, your property owners association, which is basically a specialized HOA that have a unique set of standardized rules. Then your COA, basically your
Mhm.
condos, and now your
Yeah.
co-ops, which we have been instrumental in making sure legislators include that, because as the author of SB406 will tell you, he didn't even know that what a co-op was, I believe, or that he didn't know what that a co-op existed in the state of Georgia, and they do. So this is why this line is important. We need to make sure that, you know, if they're referring to one common interest community type, they refer to
Yes.
all, just to make sure that down the road someone doesn't misinterpret and say that no, this only applies to POAs and not condos and HOAs. So we have that highlighted. Also,
So then
yeah.
again, what we're saying here, we're making sure that everybody play fair. Play fair,
Hmm.
and these are the outlines of how do you can play fair, and also making sure that everybody is included in this, if you want to have some type of a community that has that association.
Exactly. And the reason the definitions are important of who's included is because if you're an association and you're trying to fine, fee, liens, foreclose on people, if you're not registered with the Secretary of State, you can no longer engage in those activities. Um, and you could be called out by the Secretary of State and face certain consequences. And so this is what this highlighted passage is really calling out. If you're not registered with the Secretary of State, or if you are and you're not complying, you are then deemed a non-registered owners association. And if you're deemed non-registered as a non-registered owners association, you you, I, you can't do all of this
No,
stuff.
you can't collect no dues. You cannot do no legal actions towards that, the homeowners.
Hmm. Um, Yeah, and so let me jump ahead really quick. What else do
Okay.
we have here? So we have line number 108, records relating to an owners association's governing documents, finances, assessments, fines, fees, liens, and foreclosures shall be subject to such reasonable examinations by representatives of the Secretary of State as the Secretary of State may deem in the public interest or for the protection of the public. Um, What's your interpretation of that, Deetra?
Well, I love it because now we finally getting somebody to hold the home association board accountable. Even it says in the bylaws that to give you a 10-day written request or
Mhm,
a 5-day written request, and they will to get back with you within that time frame and set up a public place where you can look at your records.
mhm.
So I'm glad to see that in there because now we have someone else that we can go to, and then they're gonna make the determination and say, "Give it up."
Yeah,
And we shouldn't have to be this way if we just follow in the bylaws that
yeah.
your, association says for you to do, but this is the reason why
More
the
state
new
law.
people
Yeah,
are coming forth because it's not being done, so we need
correct.
to add it in there.
Yeah, this is probably one of the most popular, I shouldn't say popular, but this is one of the most common issues, people not being able to get records.
Mhm.
I think just about every single body, no matter what their core issue is, this is either the main or secondary issue for just about everyone I've come into contact with. They cannot get access to records that they're entitled to per their own bylaws and Georgia state law. Um, all right, so
Oh,
I
this
got the whole
this
page highlighted
yes,
right here.
yes, pay attention, everybody.
So I kind of already talked on this where the Secretary of State could suspend an association's
Mhm.
ability to fine fee for a number of different reasons, whether it be not registering, failure to comply with requests and investigations by the Secretary of State's office, failure to pay the required fee. What else we have here? It Let me jump to number 4 where it talks about fail to comply with the subpoena or an order issued by the Secretary of State. So, this is us getting back to teeth. You have a
Mhm.
lot of different states with so-called regulations and oversight, and it's not really regulation and oversight. It's just to shut people up and to provide an ear for you to cry and complain and moan about without anything being done. This is why what we're reading here is why Georgia is setting up to be one of the strongest states on association oversight, and I'm here for it. That's
Yes,
all I got
me
to
too.
say.
Me too. 10 toes down. Yes.
All right. So, this document here is available if you Google Georgia SB406, and visit the state government website. The latest version of this bill is going to be available to you. Although we expect this to change in a few days here with certain amendments, maybe in the House Rules Committee, and I do expect certain representatives to make floor amendments to this as well. Okay, this is really an extension of the previous page, where it's talking about the Secretary of State delegating his or her powers,
Mhm.
um, to various different cases and to hold hearings, under Georgia's Administrative and Procedures Act. Let me see here what else we have. We have a section of the new proposed law where the Secretary of State, once again, you know, denying, suspending, revoking an owners association's registration for a number of different issues. I'm trying to remember
And
the
and
exact
this is the one that
line.
had the removal that they can also go in there and remove?
Yeah, so I'm gonna go ahead and read this because
Yes.
this is probably gonna be one of the biggest lines that many people who have an issue with their board that they know are completely incompetent, corrupt, or even criminal is going to want to learn. So, when the Secretary of State has issued an order denying, suspending, or revoking a registration statement of an owners association, limiting the fines, fees, liens, or foreclosures that an owners association may collect or perform in the state, or barring a person who is an officer, director, trustee, or executive personnel employee or board member of an owners association under code section 43-17A-3, he or she shall promptly send to the owners association a notice of an opportunity for a hearing. So once again, the Secretary of State's office is going to have the ability to strip individuals or groups of individuals purporting to represent the association
Yes.
for a number of different issues as they
Mhm.
see fit. However, what this is stating too is that if they do that, you do get due process. They're not just arbitrarily, removing you because maybe all the facts wasn't presented and they
Mhm.
acted either prematurely or with limited information. If you're legit and you were removed wrongfully, you do have an opportunity to get in hearing to address that. So
Right.
this
And
is
then it
good.
goes back to also in both cases where you're not paying any attorney fees.
Mhm.
Because you're able now to come forth and present your facts, show a document trail
Mhm.
of what's been going on,
Mhm.
and then comparing it to the bylaws
Mhm.
to say, "Hey, the bylaws said this, and this is where you violated the bylaws,
Yeah.
and this is a fact." So these are the grounds that we're asking you to remove this particular board member or the whole board together, or demolish the covenant.
Exactly. And just wrapping up the last few
Mhm.
highlights here. What do we have here? Any person residing in an owner's development claiming that he or she has been damaged by such owners associations action or inaction may file a complaint with the Secretary of State, who shall appoint a hearing officer to conduct
Mhm.
the proceedings. Such complaint shall be a written statement of the facts constituting the complaint and shall be made with 180 days of the
Yes.
alleged action or inaction. So basically, you have about roughly 6 months to file a complaint. You can't wait years and say, "Hey, 3 years ago, I was wronged." And then also, what's different from the Senate version is you may have noticed that the Secretary of State shall appoint a hearing officer. We no longer have a board. We're going to get into the differences on another show down the road. But the House version includes not a board, but
Mhm.
appointed hearing officers. And I go back to impartiality. We need to have impartial hearing officers, if that's what they want to call it, arbitrators, hearing officers. I guess there's certain technical differences with calling someone an arbitrator, but in any event, an arbitrator or hearing officer should be impartial anyway. But I just want to make sure they're not coming from the same industry that has caused havoc for many homeowners, unjustifiably, I might add.
Well, I must say, and I'm glad to say that that's the reason why the people has the Watch Project to be there as well. So even though if that should come out to be, as they say, we got people that is being what you call them
What's that?
whistleblowers.
Yes, yeah.
Yeah,
Who coming forward? Yeah.
yeah, we're coming forward. So we're gonna make sure that we hold them accountable
Yeah.
as well. So if you need us to be there in those proceedings and everything like that, then we'll be more than
I
glad
definitely
to
want to
do
cover
it.
those.
Yes.
And I hope it's very easy to get information on when a hearing is, the dates, the homeowners association, the person, because we definitely want to cover that. We want to monitor the outcome. Like you say, we want to watch the watchers, right? So that's
Exactly.
what we want to do. So when the HOA registers, I believe they have to pay $100. That's just registration. Now, if you have a case and you bring forward a case, it looks like you or whoever loses that administrative hearing, that party will pay the $100. And that's separate from the registration fee. This seems to be a hearing fee, if you will,
Yes.
right? But only the prevailing party should not have to pay that. I thought that was interesting.
That is a good tip. Yeah.
Yeah. One of the other things that has caused a lot of heartburn and a headache for the people advocating for oversight is what I call the foreclosure loophole. So it seems like it may have been opened back up in this latest version with the House. Originally, like we stated earlier, you're not supposed to be foreclosed on for fines and fees, only if you don't pay your assessments.
Yes.
However, reading this, except as otherwise provided by an owners association's declaration or amendment thereto recorded on or before June 30th, 2026. All funds remitted by an owner to an owners association shall be applied by such owners associations to the following expenses by ranking of highest to lowest priority as follows: regular assessments or dues until current, special assessments until current, specific assessments until current, and other fees and fines. The issue with this is we should not be providing an exception to when you pay your assessment. The association should not be able to take your assessment money and apply it to fines and fees. Why? That's a backdoor way through to foreclosure. If your
Yes.
HOA dues are $200 a month and you're paying that $200 a month, they can take that money and apply it to fines and then mark your assessments as zero and then foreclose on your home. That's a backdoor way. This wasn't originally how this bill started and how it passed in the Senate. And I don't believe it's how it actually started off in the House. Why is this there? I'm going to tell you why. Industry influence and lobbying. So we need to fight back on this foreclosure loophole. I thought it was closed. And now we look at the latest version of this bill and it's clearly not closed. We need to do something about that. What are your thoughts on that, Deetra?
No, I totally agree because again, that's the reason why we need to be vigilant. We need to be understanding. We need to be reasoning because there's always a loophole somewhere where somebody's trying to get over it, and you can read everything that we don't read beforehand, and then you get down to this last little piece, and it said, "Uh-oh, I got you." So again, we want to make sure that everything is fair across the board,
Mhm.
that no one is trying to get over on no one, and that is not what anybody wants to live in or be a part of an association or a community, is that's what your ultimate goal is. I'm
Mhm.
going to play this game.
Yeah. One of the other financial areas that the Watch Project has been advocating for from the very start when we put together proposed legislation is prohibiting associations from refusing payments. We saw this with Karen and Sharina from Wildwood Co-op, where
Mhm.
the association was like, "I don't like you, and oh, you got your payment? I'm not taking it, and we're going to pursue collection activity against you to get you out of the neighborhood." So they've plugged that loophole, so no association can refuse payment from an owner for any reason. And so that's really good. Another thing that they prohibit in this version is that they're no longer able to accelerate dues. That's not something that often happens, but if you don't know what that is, basically, usually within a calendar year, your governing documents will allow an association, once they started collections procedures, to say, you know what, you haven't paid your dues. We're calling all of your dues due now that you would not normally have to pay throughout the course of a calendar year. So that's been stripped out. Another thing I want to jump to really quick is the verbiage related to foreclosure. So right now in Georgia, you can't foreclose unless the bill is $2,000.
Yes.
The issue we have with this wording is the lesser of $4,000 or an amount equal to 12 months of regular assessments as such term is defined in the code section in arrears, but not less than 2,000. So really, they double the amount that the threshold, but not really if you don't pay your dues for 1 year. Honestly, as someone who is on a condo board and, you know, condo expenses are very finicky. If someone doesn't
Mhm.
pay their dues for an entire year for a condo, if it's smaller, that can mean the water getting shut off for an entire community, the lights getting shut off. I mean, a lot of people that I work with, they want a $10,000 threshold, a $20,000 threshold if you're gonna before you can foreclose. And my thought is, if you're gonna do that, you need to keep in mind that many condos don't have that kind of runway. They don't have that leniency with the local municipalities, the electric company, and so if that's your mindset, just keep in mind that certain condos are gonna fail, and if that's something you're comfortable with, just be honest about that.
Mhm.
But just so everyone out here knows, the media may have reported this as doubling to 4,000, but once again, that's only if you are paying, but if you haven't paid for a year and your amount is 2,000, they can still foreclose on you. So, just try not to get to a point where you haven't paid your association for an entire year, get on a payment plan or something. I think that's reasonable within a year to at least pay your dues.
Exactly. Exactly. Try.
All right. So, we're gonna go ahead and play a clip for you all, um, from the last what is it? The last
Thursday.
Georgia House Judiciary, um, meeting. So, let me go ahead here and share that with you all. All right, here we go.
Losing your home over an HOA fine can soon be a thing of the past here in Georgia. A bill to rein in the power of homeowners associations in our state is a step closer to law. As Atlanta News First investigator Anastasia Almos has highlighted in her series, HOA Nightmares, there's currently no office that oversees HOA issues. So Anastasia is live now from the Capitol. What is the reaction to all this today, Anastasia?
Well, Blair, Senator Matt Brass, he sponsored this bill, the HOA Oversight bill. It's really the most comprehensive oversight bill that's happened here in this state, and it's the only HOA regulation bill to make it this far in the Capitol. So it passed today, the Judiciary Committee in the House, but not without several changes. The Secretary of State would still have oversight and enforcement powers, but the original 5-person review board that was once proposed in this bill is gone. Complaints would now go to a hearing officer. The state can make a decision after a hearing, and court would be an option in the appeal process. It would also require an HOA to submit the previous 3 years of financial documents to the state, allow the state to deny, suspend, and revoke an HOA's registration, and it raises the foreclosure threshold to $4,000 in unpaid dues, not fines or fees, and gives homeowners 90 days to pay and fix it. Now, homeowners and advocates tell me they're happy, but also worried it's not enough.
The bill states that you cannot be foreclosed on if you pay your assessment. So gone are the days of losing your home because someone doesn't like who you are and they send you an arbitrary fine or fee related to that. So the bill looks great with one glaring exception. We do not have impartiality and we do not have a board.
The bill also allows HOAs to opt out of registering, but then it cannot issue fines, fees, liens, or start foreclosures. So now Senator Brass tells me that Representative Ray Martinez will carry his bill on the House floor, but we know it will have to pass out of the Rules Committee and get a vote before the end of session on April 2nd. I'm Anastasia Olmos, Atlanta News First investigates.
There you go.
What a good way to end the show. I like that.
What's that?
I said, what a great way to end the show. I like that. That clip was awesome.
Almost. The last thing I'm going to tell you guys is that we need to contact the Georgia House Rules Committee. And we need to make sure that SB406 gets to the floor. I don't think the Rules Committee is going to do anything related to making sure that the people that the Secretary of State office appoints has impartiality. So, we're going to be leaning on you all to reach out to your representatives to really push that point. I know I definitely will. I'll be working the Georgia State Capitol as a lobbyist on behalf of the Watch Project, which is basically lobbying on behalf of any reasonable homeowner. And let me see here. I just want to share with you all the names of the people before we get out of here. Who is on the Rules Committee and what their contact information is, because these are the people that need to hear about the issues going on. So the chairman is Butch Parrish. He's the chairman. He's the one who's going to be bringing up and helping schedule SB406 to get a floor vote. There you see his email, butch.parrish@house.ga.gov. His phone number is 404-656-5141. Call up his office, tell his assistant, get in contact with him, go to his Facebook page if he has one, go to his Twitter if he has one, go to his LinkedIn page if he has one, and tell him we need to fix the issues that we talked about. There shouldn't be a loophole for someone to still foreclose on your home for random fines and fees, because they're going to still target you for foreclosure. So that's not a real protection. I don't know why they would go back and change that. You got the vice chairman, Rob Leverett. There's too many people to name, but if you go ahead and just Google Georgia House Rules Committee, this webpage is going to pop up. Click on them, work them, and contact your own representatives and let them know how you feel about this, because right now the lobbyists, the industry, community associations, institute, they're working overtime on stopping you from getting justice, because they want you to have to go to court. They want to keep raking you over the coals. They're removing comments, and these are not disrespectful comments, but they're encouraging people to say, oh, tell your senators this is the end of the world. What is the end of the world about getting the documents that you're entitled to? You have representatives from CAI Georgia going to the Capitol saying, oh, well, if you have an issue, just sue your association. Not everybody has $40,000, $50,000 to sue. Not everybody has 6, 7, 8 years to be tied up in litigation over the most basic stuff. Of course, they're going to tell you that, because they're going to be trying to get fees from you. They're going to be charging the Homeowners Association. They don't want to see a remedy that stops short of court, because it's cutting into their bottom line. They should be in justice, not in business. And that's the issue with too many of those people. So once again, contact all of these people on the Rules Committee. Go to the watchproject.org, sign up for our mailing lists, our newsletters, our articles, our content, our videos. That's coming. That's active now. That's going to be emerging, because enough is enough, Deetra. I'm sick of it, and I'm sick of these people. So we need to get something done.
And the people are standing up because they are sick and tired of being sick and tired, and their pockets are being empty. So let's see, can we get our money back and then do what we need to do with our money, or what we agreed to when we moved into these communities.
Exactly.
Let's just take care of the common area.
And it's working. It's not just me. It's not just Deetra. It's not just Amanda. It's not just Caroline Simmons. It's not just Christina Potts and a whole host of other people I can mention right now. It is people, calling from every corner of Georgia, calling their representatives. I get the emails that you guys are sending. I know I get them because I respond to them. It's working. We have an industry group with millions of dollars, and what do we have? We have our voice.
Yes.
And it's working. We're getting legislation passed. We're getting specific amendments passed and passed unanimously, but we got to keep the pressure up on the House side. That's where they've dug in their feet. That's where the industry lobbyists are setting up their final defenses, and we need to overcome them and overthrow them because they don't have your best interests at heart. They really don't. And I'm going to go out and call them evil because they're literally stepping in the way of justice. They're painting a picture that the gates of hell is going to be open. Well, guess what? The gates of hell are open, and we're trying to close them.
Right.
So
we are in hell. So if you're tired of being in hell, come on, take back what already belongs to you. And we need to stand up and form together. Get out there and start emailing, start going on their social media, blow them up, and let them know enough is enough.
Yeah, blow up their phones and emails and show up at the Capitol. Just want to specify so we're not misconstrued. Yes.
Yes. So we just thank y'all so very much for tuning in to the Watch Project show. Continue to pass it along, tell others, click like and share, and come on board. We want to hear from you.
All right, see you guys next time.
Bye.